The Housing Scotland Act 2014 will introduce quite significant changes in the field of housing management law. It will introduce new rules about the allocation of tenancies, about how persons on a housing list can be suspended. It will introduce new rules about how tenancies can be assigned or transferred by one tenant to another, about how a tenant can have a sublet or a lodger. It will change the rules on the use of what are called short Scottish secure tenancies by increasing the availability of them to landlords, and it will introduce new rules about the eviction of persons who have been convicted of criminal offences while a tenant of a particular housing association or local authority, to make it easier for that landlord to evict that tenant. The changes under this Act will be introduced over the coming year. The Act itself was passed nearly 4 years ago, but for various reasons the government have just never managed to get round to passing what's called the implementation regulations. There's going to be a whole set of guidance given by the government to local authorities and housing associations. It's all ready to go, it's all been drafted, it's all on the government website, and we expect the implementation regulations to be introduced this year, possibly in the next month or two, and the idea is that all of these provisions should be enforced by early 2019. The 2014 Act will have an impact on many areas of housing management practice. It will require almost every local authority and every housing association to change the rules about allocation of tenancies. In other words, who gets what tenancy and what you need to do to get a tenancy. It will change the rules of what we call suspension of tenants. In other words, can we prevent someone from getting a tenancy because of their previous behaviour, such as not paying rent in a previous tenancy or misbehaving in a previous tenancy. It will change the rules on the use of short Scottish secure tenancies, which are designed as an introductory or probationary tenancy. It will change some of the rules about eviction from tenancies on certain grounds, and it will also change the rules about how tenants are allowed to assign or transfer their tenancy to someone else, or how a tenant might sublet a tenancy for a period of time. This Act will allow public sector landlords to use short Scottish secure tenancies much more widely. At the moment, there are a restricted number of reasons why a public sector landlord would use a short Scottish secure tenancy. One of them is when a tenant or a person looking for a house has previously been engaged in antisocial behaviour. But at the moment, the rules require that before you can give that person a short Scottish secure tenancy, the antisocial behaviour must have either led to their eviction from a previous tenancy or an antisocial behaviour order, which is a court order telling someone you must not behave in a certain way and with certain penalties attached. The new rules will allow public sector landlords, that is local authorities and housing associations, to use whatever intelligence they may have about the behaviour, either ongoing or prior behaviour, of an applicant, and use that to decide, we are going to restrict your initial tenancy to this short Scottish secure tenancy. It's for an initial period of 12 months in an antisocial behaviour case, but can be extended for a further 6 months up to 18 months. The Act is designed to make it easier to evict tenants who've been involved in criminal antisocial behaviour. The current law allows a landlord to evict a tenant if they're convicted of a crime which is committed in the tenancy or in the locality of the tenancy. Mainly that's been used in respect of offences relating to controlled drugs. For example, a tenant being found in possession of a large amount of controlled drugs, or using the property to cultivate controlled drugs, particularly cannabis. However, when you go to court at the moment and you look for an eviction order based on that reason, the court must also be persuaded that your order is reasonable. In other words, the tenant can argue that even although I've been involved in the criminal behaviour, you shouldn't evict me because of my health, my children's health, my partner's health, the other neighbours quite like me, etc. So when this new ground comes in, we're going to remove that reasonableness test. We're going to make this particular ground a mandatory or automatic ground. In other words, if you're convicted of a criminal offence in your tenancy, the sheriff must grant the eviction order. there will be no requirement for the sheriff to consider whether or not it is reasonable that the order should be granted. That should make it easier for public sector landlords to remove the criminal tenants from their tenant group.